Welcome everybody to Your Bytes, Your Rights, session 16 on the American Data Privacy and Protection Act. This is sort of a big episode because it's sort of a lot to take in. This bill just dropped last week, and it's sort of a big one. There's actually only about a month left in session for Congress to debate this act, and it's a lot to take in. I've actually written quite a bit about it in a couple of different posts, and I'm going to let Heidi talk because we're sort of running out of time for her to give us some thoughts on it, and then we'll sort of go back and talk about it after I let her talk a little bit about what she thinks about the act. So I'm going to give you the stage. Go ahead, Heidi, introduce yourself and give us your thoughts.
Okay, my name is Heidi Sass. I am a data privacy and technology attorney. I live in the Washington, D.C. area, and I'm excited about the prospect of this being introduced in its revised form. I like the draft that they came out with, but there are a lot of flags in there, and I think they're testing the waters of where they're going to get pushback. There are some significant areas where they're going to get some pushback on this. The private right of action. Why 4-year waiting period? Well, that's so that they can reach all the way into the next administration and ensure their chances of clawing back some of these protections before they take effect. So that's not really a good thing. That's kind of Cantwell's problem. And so there's a hearing on Tuesday. Things are going to move quickly to see, where everybody stands on the issue. But Cantwell is toying with the idea of having her own hearing on the same day, just to let you know she's not really on board with this. So I think from a consumer rights perspective, it does a lot of good things. I like the rights of access, rights of correction, deletion, and portability. Those are important. And I think that it's bringing a lot of attention to the issue for people because they understand what the harms are from having so much data out there being used against us all the time. So I think that's important too. One of the most exciting things that I find in there is the data broker registry. That's great. That's going to resolve a lot of issues. Having the FTC with a newfound energy to go after these types of issues. That's great. But the most important thing, I think, is algorithmic bias and those issues of AI and audits and, baselines being set, best practices being established, because the black box is not really a black box. A lot of us understand how it works and we know what the problems are and how to solve them, but we really need the opportunity to do that. So I think working with the working group at For Humanity, we're working on proposed audit criteria for how to conduct one of these audits on an AI system in hiring for the new regulation in New York City. And it's very difficult to get these machines to do exactly what you need them to do, and they have to be constantly monitored, but you've got to feed them the right kind of data and it needs to be trustworthy. So until we have foundational rights in our data, we can't clean up the data being fed into all these systems being used in all industries. So that's kind of the beginning step, is let's get some rights in our data, then let's start building more trustworthy practices, and then we could move forward. So I really like the fact that it encompasses AI for all of the industries, not just specifically the one in hiring, and we have to go piecemeal in legislation by industry. I like that it just blanket covers the whole tool of all of AI. So that I thought was really big. Are you finding more people? How are we doing?
Yeah, we're still working on that, Heidi. Tell me though about the AI coverage. It seems like a really good first step, but is there going to be a problem with preemption of state laws? Because if this is really just a first step for AI regulation, it really only talks really about audits for AI. Is this going to be a problem because we won't?
No, they opened the door to rulemaking for the FTC. They said, you need to get into this and you need to start rulemaking on this. That's far more dangerous than the state law. That's definitely far more dangerous right there. So I think that is where I have the most hope and where this is going, because there are so many things we don't know about how people are using these tools, and people definitely don't even know when these tools are being used. So, it doesn't need to go industry by industry, because not everybody needs a carve out, because basically these tools are made the same way. So we need to work on developing, and we need to stop making so many copies of personal data. We need to start, asserting more ownership of data so that we have access, not copies, like it says behind you there. But the thing I see is an opportunity for people out there, especially those that are already working in privacy. And you may find yourself out of a job right now. Please look at going into auditing. We are going to need so many auditors that understand data because of these regulations that are coming forward. I'll tell you right now, we don't have enough auditors. So the more people we can get that already know what they're doing with data, please look into For Humanity and other courses so that you can start getting certified as an auditor so that you can do the work on AI bias and all of these issues, because it's going to be regulated one way or another soon.
Yeah.
So there's opportunity there for people, right? There's something good on a Friday.
Yeah, there definitely is. And I'll talk a little bit about that. I know you have to leave here in a moment, Heidi. So I'll talk a little bit about what's going on with For Humanity and their audit stuff after you leave here. Hopefully we can get more people on stage. I'm still trying to get Chris back on his titles.
Yeah, I'm here. I'm
there
here,
he is.
guys. Sorry about that. So my guest just left. So, and I'm on my laptop, so it's going to be a little awkward here since I started this from our conference room. So who do I need to bring on here?
Odia Kagan first.
Okay.
And also Tom Besor, if you can bring him up, that would be great.
Okay.
And I want to hear from both of those people, and I gotta go.
Okay.
And, you know, I always call him Tom Besor. It's Tom Besor. So my apologies.
They should all be on now. Yeah, sorry, I had guests from Asia showing up at
it's like there's this stressful moment where it says apply to join in a panelist, and then you're like, are they going to accept me? Like, is this going to happen? There's this black screen and you don't know, but yeah. Okay.
You made it.
I made it.
Promoted 2 women so far, and the whole call, we're only 14 minutes in. Right on, guys.
Sorry for those technical problems, everyone. Appreciate your patience. So you know, let's just dive right into it. You know, there's a lot of different pieces that we could cover. I sort of walked through a few of my thoughts on this bill, but let's just go ahead and get Odia's thoughts. Do you want to give us sort of your overview, Odia? Is this good for consumers if this were to pass?
I think so. I think my first reaction was, I mean, this is the first thing is, right, the spiel that I think I even said it on your show like a week or two ago that, you know, no fair information protection principles were harmed in the failure to launch a federal privacy bill to date, right? Because the disagreements were always about non-privacy things. They were about private right of action. They were about preemption. They were about who enforces. And so the first thing I think is if, because I am not, you know, a good like political gossip person. Like if, you know, the people that know the 3 corners and the 4 corners and all that stuff of the bill can speak up. But I think that what if and when those issues get settled, I think that the privacy stuff will get settled. So, and then we will have it. So then with respect to the privacy stuff, actually my reaction, so there are a lot of things there that are sort of, there's things that are bracketed for discussion and there are things, but generally speaking, it was more comprehensive and more strict than I had expected. So that was an interesting surprise, right? Like age 17, okay, and that's surprising. The first thing, you know, I can, maybe you have like more sort of like specific questions, but a couple of things that like spring to mind. First of all, let's not call them covered entities. Like everybody who's ever done HIPAA ever is like banging their head against the wall. And, you know, so like, that's not great. The other thing is, I actually don't know where did the DPIAs go? My personal kind of guess, and I don't know if it's true or not, we will see. Now you're recording this and like you have my face attached to it. So I don't know, but I think my sort of, you know, thought is that DPIAs are going to be written in through one of the FTC rulemakings that are anticipated in the law. Why? Because first of all, because there's this thing called like technical compliance certification thing, which is interesting because that speaks to me like a, like a code of conduct-y type thing, like under GDPR, like the certifications and codes of conduct, which is really good because people keep asking me, oh, can I get certified under, CPRA or GDPR? No, but unless you're in Luxembourg and don't do cross-border transfers, in which case, if you are, yes, you can, but the rest of us. So I think number one, it will probably be part of compliance. We've seen it be something that the FTC has looked for in, like, when something goes wrong, the FTC was like, well, why didn't you think about this in advance? And why didn't you document your thinking? So we've seen it that way. And the other place we've seen it, which I think is a good maybe preview of what we might expect, is the Tim Hortons decision from Canada that came out last week. So they basically said, oh, the fact that you didn't do a privacy impact assessment to ascertain the impact of your data, your geolocation, precise collection of geolocation in your app, that is a testimony to the fact that you are not doing what you are. This is an accountability failure. This is a necessary and proportionate failure, because you can't really figure out necessary and proportionate unless you've done a privacy impact assessment. And so since now we know that both the CPRA, as per the new regs, and the ADDPA, as per the draft bill, are very serious about data minimization. Like, they are European level serious about data minimization and purpose limitation. I think that the DPIA is going to get baked into it somehow. And with staying away from the very formalistic kind of way of doing it, which also, frankly, is what England is doing now. Like, DCMS is also not happy with the overly kind of formalistic DPIA situation. So they're saying, okay, well, maybe we don't need a full one in every case, and maybe we need, we're not going to set standards. But so I think DPIAs aren't, first of all, formal DPIAs are in there for the large data holders, number one. And for the rest of the companies, I think they will de facto be baked in to the requirements, maybe without the overly difficult / expensive formalities that SMEs are, running into with respect to DPIAs.
That's a really good take. I like that. I read a little bit of an interesting look at how this duty of loyalty is written to the bill. And sort of a question as to, is it really talking about principles of a duty of loyalty, or is that more of a value judgment? Is it a, if you look at the duty of loyalty in every other bill that's ever been put forward, a duty of loyalty really means sort of hold harm. No, I'm not thinking about this right. That you have to sort of balance what you're doing with data in terms of whether it's going to harm customers. And while it mentions duty of loyalty in the ADDP, it does not go in that direction with this duty of loyalty. It really just talks about some principles, right? Data minimization and a couple of other things, right? So it talks about duty of loyalty, but it doesn't actually talk about duty of loyalty in the way people might expect.
And I think, I don't know if Thomas is trying to say anything and I'm cutting him off because he's on mute. You're on mute. So I don't know if that gives me a right of way here, but
it does.
Good. It does. I think, I don't know, but I think it may not be, it's not necessarily a bad thing, right? Because duty of loyalty is a very controversial concept. It is a very lofty concept. And it's a concept that companies are going to have a very strong gut reaction about, of like, let's sit and like sing Kumbaya and like the fire, fire pit kind of thing, right. Which is not really going to work, right? Especially not in the US and all that. I think what they are doing here, and this is really, so I posted a summary on LinkedIn, I posted a summary of the ADDPA, and as I was reading it, I was summarizing duty of loyalty. And then as I was reading it, I was like, oh no, they actually didn't mean duty of loyalty. So I don't even have the title in my summary. I just went straight to the points. But I think that what they did is, so the controversial pieces of duty of loyalty, which is, don't consider companies, don't consider your own well-being, consider only the well-being of people. Like that's, I don't know, can I say un-American? It's kind of un-American. Like it's not really gonna go far, right? On the other hand, right, the concept of which we have been seeing in Rebecca Slaughter has said it, Lena Khan has said it, on the problems with notice and consent, right? And we talked about it in one of the previous episodes, right? The problems with notice and consent, the need to have a more top-down approach that requires companies to do a before the fact analysis of what needs to happen. I think they're doing that here, right? They're doing serious data minimization. They're doing serious purpose limitation. They're doing really serious dark patterns, right? Arguably on par with what's going on with GDPR, on par with like the FTC sessions and all that, taking it further than the CCPA regs. You only do the dark patterns and opt-outs thing, even though the CCPA regs also expanded it now, right? So like real dark patterns. Then they also have real Article 7 GDPR consent for stuff. Okay. It's sort of like very specific stuff maybe, but hits a lot of the big ticket item problematic stuff like precise geolocation, biometric information, genetic information, certain things we can connect with targeted advertising. So I think they do a lot of these things, and privacy by design. They have an express duty for privacy by design. And then also like, the CCPA style non-discrimination because of exercising your right. So I think they hit a lot of these points where these things, even without being prescriptive, are a huge game changer for companies. They're a huge game changer for companies. I had a data minimization purpose limitation discussion with a client like a few months ago, and I said, anticipating CPRA, I don't think that you should be doing this. It's risky. And it was like, what do you mean? Like it's there. And it's a huge, like, it's such a big, like thought change, I think, for companies that I think it may not necessarily be a bad thing to stop short of, being, what do you call those Delaware corporations, like a corporation for the benefit of society or something. There's a type of, so maybe it's not horrible to stop there.
Yeah, I agree with you. I think this is going beyond notice and consent. I mean, there's still consent here, right? And there's some express consent, which is really great for sensitive personal information. But it's not a kumbaya. It's not a B Corp. It's not turning companies into B Corps. But it is a step beyond where we are now, where everything is notice and consent, and customers have to, buyer beware, caveat emptor. I think it is promulgating rules that protect consumers in ways they have not been protected up to this point.
Yeah, I think so. I actually just read, I was traveling and I actually just finished, and on the plane, I read Why Privacy Matters, the book, Neil Richards' book. And it is, you look and like, he gets an A for like ticking all the whole part of the book was like, I am not going to anticipate what a future privacy law should look like, but I'm going to say X, Y, and Z. And the new law, interestingly, really hits a lot of the points. I think maybe the only one of the points that it doesn't hit, which because maybe it's too much for US laws, is actually but actually Keneal in the cookie walls hit that last point. But it hits most of the things, and the argument that he's making in the book, which I thought was very interesting and eye-opening, and a way of looking at things, was he's basically saying, okay, right now we're in the information revolution. The previous revolution we had was the Industrial Revolution. When the Industrial Revolution started, there was a lot of stuff that was happening, and it took a while for the laws to catch up with what was happening, and we had a mess in the beginning, but then the laws sort of caught up. And now we have the Information Revolution, so we have a mess. And the Industrial Revolution laws are not catching up with the Information Revolution problems. And that's why we need a law that will. And he's basically hitting the points that this caveat emptor thing is an Industrial Revolution concept, because before you didn't have that. And you know, bad things were happening, right? So now he's like, well, this falls short of what we need, because this emptor is not, he calls them econs, right? We're not like perfect beings that know everything and have all the information is floating and the market is perfect. The market is not perfect, and we have perception biases, and we're overloaded with stuff, and we have, you know, clicks that are not real toggles, and we don't know where the data is coming because it's shared with 300 companies and then another 3,000 and then another 500,000, right? So basically saying that this notice and this stuff that we need, the data minimization, the purpose limitation, you know, the fair and lawful analysis, right? The necessary and proportionate, which even if you take the Canadian interpretation, right, which is what the regs have, is this is something you can't do it unless a person reasonably expects this to be happening. And obviously reasonable expectation is partly what you tell them, but it's not everything, because you can't just tell them, hey, you know, I would like to take your firstborn and sell them to Satan, I accept, right? Like you can't do that. That's disproportionate maybe, right? Unnecessary and disproportionate, but you need to have that in order to, you know, kind of match the laws with the issues that we're facing.
Yeah, maybe that is actually the solution. There was a British publication that did an experiment where they updated their terms and conditions to include the fact that their readers had to clean up the city. And so then they were informing them at some point in time, telling them, well, you consented to the fact that you should be picking up trash for like an hour a week or something. So we're enforcing this now. So please, everybody go out and pick up trash. And I'm totally mangling the story, but kind of you see the sense here, right? So the other point there being, so I'm looking at the cliff notes for the proposed new regulation. And so what strikes me always when I read those is they don't seem to understand that this is more than just privacy, and this is more than just not collecting data. It's actually earlier. It's the fact that we should know that we are not being observed, right? Because already observation, the fact that you're being observed is changing behavior. And that should be kind of like almost popping up in the entire time, disclaimer, disclaimer, disclaimer. You probably at some point in time walk by a sign that said something to the extent that this area is surveilled by blah, blah, blah. And if you're doing blah, 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 then blah, blah, blah comes and comes down on you, right? So in essence, that's what every website, every publisher would need to do as well. At least kind of for a period of time before we dial it back to realize, oh, by default, we shouldn't actually create the data to begin with. It's not about collecting, it's don't create the data. And it starts before that, as far as I'm concerned.
I think there's, we definitely need notice, but you know, I think we're getting in some places too much of that notice, right? People are ignoring that notice now.
Sure.
But we have to be careful about that, right? How we're doing that.
Yeah. So the way I envision this is kind of, I keep making the same example. If something is happening to my account, right? So my bank account, I want to get a notification. I want to be able to swipe left or right. And then if you extended that to the extent, well, someone wants to pull my data, swipe left or right. And then eventually we'll have a setting. It's like always swipe left. Well, I forgot what is no and yes. I think swipe left is no, right? So always swipe left, right? So that's my default position on that. It should be that easy. That's the thing. So like for things like checking out or something else, you have like one by button, whatever, right? And people get patents on that apparently. So that is the more important thing, that we get these choices and get agency back on what should be happening when I engage with technology, right? So I don't get into my car and my car takes me the way it wants to go. Same with a website. I don't expect the website to social engineer me into going to a place that I wouldn't be going if the website didn't have 21,000 data points on me. Right? I don't see it any different. Technology should serve the human.
I think the law is requiring more than what you are saying they should. I think they're taking this a step further. They're saying, I think the idea is, I think what they're saying, so we'll see how this plays out, but the way that I'm reading it, it seems like it's playing out the same as in Canada and essentially the same as in GDPR. So what they have is, one, there is a duty of transparency, right? And the duty of transparency is very specific. And we see all of the work, and even if it gets preempted, I don't think that all the work, because the CPPA gets to enforce the ADDPA, I guess, right? And they you can maybe, it's like with fractions, maybe they can cancel out the P's and we're only left with one P in the top and the bottom. But anyway, they get to enforce it in Canada, right? In California, right? So the work that we've seen with transparency, I think, stays. So transparency needs to be serious, and you need to disclose all the purposes. And then you're like, oh, well, actually, I have another purpose that I forgot to disclose. So then you need to think, oh, is this purpose compatible with what I've been doing? And there is, there's a lot of stuff written about compatibility in Europe, like what is a compatible use? And if it's compatible, then under GDPR, you're like, okay, well, you maybe have solved your legal basis thing, but you still need the transparency thing because it is not compatible if you don't know about it. So then you need to tell people, and I think you need to either tell them and give them the opportunity to object, right? And then, so that's so that's one option. The other is, now you want to do something that is just completely unrelated to anything. And you want to do, I don't know, the law in the CCPA regs, give a bunch of examples of incompatible uses. And they're like, oh, I've collected information and now I want to use it for targeted advertising, right? So that is incompatible. That you can't even just say, hey, heads up, we're doing this, and give us, if you want to object, blah, blah. That needs explicit opt-in consent because it's so weird. So this swipe left situation, I think the law is saying, okay, well, if it's incompatible, you've got to interrupt this programming in order to bug me for a consent, right? But either of those are actually further refined by the fact that they need to be necessary and proportionate to begin with. So you can't just say, hey, now I want to share your information with Satan in order to, I don't know, target advertising you from hell or something, right? You can't do that if it's not necessary and proportionate. So that further reduces the interruptions.
Yeah, obviously, to a large extent, it depends on what data we are looking at, right? So if you look at surveillance laws, right? So as a government agency, you have to do two things. You have to obtain a warrant, and to obtain a warrant, you have to show probable cause. So every time it comes to actual sensitive information, and I would include any kind of purchase information in that, at that point in time, that standard should apply. Show probable cause, show me your warrant, otherwise you don't even get to observe this behavior, right? So it comes back to where we have cryptographic primitives to attach PII to transactions only if there is a warrant, a legal requirement, then doing anything else is actually unlawful from that particular standard, right? Is that too obtuse? Or?
No, I agree. I think that the law is this the warning signals that I've been sending clients before. It's like, guys, look at what the FTC is saying. Look at what the FTC is saying. You can't just, it's like, until now, right? Until the FTC, it's not really, because the FTC has been saying this in, you know, the 2012 paper and the 2014 paper, and, you know, lo and behold, they agree with their own papers, which is good. But until now, right, it was like, I do business, therefore I process, right? You know, I think, therefore I am, right? Like I do business, therefore I can do it, right? And then you were like, okay, paper it properly, and, you know, don't do it retroactively, because the FTC said don't do things retroactively. But like, basically it's like, this is what I feel like doing. So, you know, by continuing to breathe, you agree with this, or don't use it, or like, don't use the service or whatever. And now there, with the adoption of data minimization, purpose limitation, as well as an, you know, GDPR like Article 7, this is no longer the case. It's not really like, hey, if you don't want to collect, don't use the service. It's, you need, you know, there is an Article 7 thing. It's like freely given and, you know, unambiguous and revocable and everything. So I think it is making companies. And then there's also the other layer, which we all have seen in different laws also, like the ethical and the discrimination layer, right? Imposing on companies requirements to basically say, and that's why I think it sort of builds in a de facto DPIA, even without it being like a you know, 500-page, you know, German style DPIA. You still need to think like, it's like, you know, you do a DPIA like under the UK style, you can get away with 50 pages. In Germany, 500 pages, like, where did you, like, you left out half, right? But but I think the key things of asking yourself the question of, you know, is this actually doing what I needed to do? Could I be doing it in a different way? You know, is this really, do I really need to collect biometrics, or do I not? Can I just retain tokens and yes or no's or whatever? Like, that analysis needs to now happen. I think it's a higher standard than companies have been held up to until now.
Yeah, Eric wanted to say something, I think.
Thanks for bringing me up on the panel, and nice to meet you both. I think that.
Why is it not nice to meet me? Wait. Why is it just both? Anyway, nice to meet you.
Sorry, because I already know Chris, and so it's you and Jeff.
Got it. Nice to meet you as well.
Okay, maybe there's like 50 other people in this call. I don't know, because I can't see them, right? But
there's more than us on the call. Yes.
Okay. All right. Anyway, I wanted to raise a point that has more to do with practicality or pragmatism than necessarily with ethics or certainly with law, and that is, notice is de minimis, right? At the very least, you need to have notice, but you have a problem inherent in notice, which is the cognitive complexity of the guy receiving notice and the sort of universe of consequences for the decision that he makes, and whether he's capable of figuring out, and whether or not that's actually part of the notice, right? So, you know, if we think about notice today, when I go to Facebook and I create a new account, they say, okay, here's our terms of agreement. These are yes or no button, right? Okay, there's notice, but who can actually read that? What does it even mean, right? And so you could say, okay, well, maybe you don't need to give the entire notice all up front. You just sort of start slicing it into small pieces, and then you keep asking for, or you keep giving notice and asking for permission on a much more granular basis, right? But the reality is going to be that the world is just a very complex place today, and most people cannot come up to the level of cognitive complexity necessary to make the right choice. So what's the point, right? The point is that as the grandfathers were, or as the elders, we're here to try to figure out how to protect people from their own ignorance or their own incapacity to deal with this difficult world that we live in. And can we actually do that? And so I just wanted to sort of raise that point and get a perspective from you guys on the issue.
I mean, I think the law is trying to address this. This is, I think that's what they're trying to do. So the argument that is being made, and I mentioned the Why Privacy Matters book, which goes into this issue in great detail and lays out the different, you know, the Kahneman and Tversky books on, like, you know, biases and, you know, predictably irrational and like things like that, right? So they're basically saying, oh, hey, we know we have problems, and therefore we need to have a transparent, so it's two things, right? Number one, we are incapable of making all of these decisions, right? And therefore we shouldn't need to. So that's where the law basically is saying, well, you can't just dump everything on people. I was saying, I don't know if you were listening in the beginning, but I said, okay, well, we can say, you know, I would like to sell your firstborn to Satan, I accept, right? Like, you can't do that because that's not a choice that people are able to make. And it, you know, disadvantages the disadvantaged, you know, and unprotected parts of society and things like that. So the first thing is, there is at least a certain level where now the onus is on the company to say, okay, am I even allowed to bring this to the discussion, right? This is the sort of, you know, this is the sort of situation. It's like those things where you know, like you have a discussion with yourself in your own head before you go to your spouse. It's like, oh, we got to talk. No, like you sift out a bunch of stuff first, right? So there's a few things that companies are like, well, we're not even allowed to bring this to the table. Then
this is the labor law discussion, right? I mean, when you enter a contract, it's a willful act on both sides, but there is a de minimis, you know, code base or law base that says, as an employer, you may not, you know,
right? Because employees are by definition deemed to be a more sensitive population because of a disparity in bargaining power. So this is saying, okay, we know that people can't just be, one, there's too much of this, two, they are unable to decide. Okay, so we're going to raise, first of all, we're going to cut some of this out. Companies can't even ask the question, right? That's number one. Number two, when you are already asking the question, there are a bunch of limitations on what to do. Number one, you need to be able to, so this is part of it, is the design interface things, right? Like you can't like pull one over people. You can't keep nudging people. You can't just like, you know, badger them until they say I accept because, you know, because that's inappropriate. So that's the manipulative design issue, which is being handled in the law. So you can't like design things so that people are manipulated into it. There is a law in California that actually talks about manipulative design in the context of addiction and like social media and addiction. So that there are other laws that tackle that. Like you can't take advantage of people. We're going to take care of one threshold items, two, manipulative design, three, the other piece that the law is doing is it does handle transparency, and this is going to be a long road. And I frankly don't, I mean, I'm thinking and wanting to learn the solutions, because I think even when you have done the necessary and proper thing and taken out the manipulative design and taken out, you know, other kind of, you know, designs that are meant to like, you know, make people stick around as much as possible, and also handle market imbalances, which means one of the things that the FTC has said, and it's not in this law, but just generally is, okay, well, privacy is not the only way to regulate this. We need to regulate this through competition law, through, you know, market, a more regular market. So, okay, now you have, you know, more actors. And so the market is regulating itself. But at the end, there's still going to be a set of things that, you know, are going to be you're going to need to give disclosure about. And the law, the CCPA regs, if you look at the regs, because they're in more detail, and even this law, the requirements of what you need to disclose, with the overarching principle of you've got to disclose it in a way that normal human beings understand, is really difficult. And I say that with having, you know, drafted a privacy notice for 3 hours today and trying to understand. I actually took, this is classic situation. We took a privacy notice that a partner had drafted, not a partner in the firm, a partner company had drafted, not our client. And we had to, and we rewrote it because we didn't like it. But the issue was, not only was it formatting, as we drafted it, there were so many, like we do, if I have questions for the client, they're all yellow highlights. There were so many yellow highlights because importing the privacy notice from the way that it was drafted to the way we wanted to draft it, there were so many holes of information that were not there because it was vague in the first draft. And in order to do that, one, there is a lot of work that companies need to do because this level of granularity isn't there. It's like, we are using this information to improve the product. What information, what product, what improvement? Like, one, you don't know. And if you don't know, the person doesn't know. Now, if you then get to the level of granularity that you need, you still then have, I don't know, 9 pages, 10 pages, 15 pages of people reading things that maybe they can comprehend, but like, dude, it's 15 pages. I would rather read a book, right? And I understand that the app now takes this type of thing and that, and it uses that to understand where I'm from and figure out what area is this. And it takes that thing to understand my age and make it like, okay, well, I can't, do I really need to know that you're wanting my age bracket for this and my, like to that level of granularity? So then, and what's the solution? And they're gonna, the grand solution is you need to give information in a way that people find most useful. That's the standard in the law. And then the question, we need to hope maybe an industry standard, maybe we need to test this out with people. And the law actually, I don't remember if it's this or the regs, they actually say, go test it out, I think it's the CCPA regs. They say, go test your methods, see if people are confused. And the ICO is also like, ask people. And maybe at some point we land on some sort of industry, not industry standard, but like maybe market standard. People are like, you know what? I don't really care about this, but I really do care about this. So I would like you to convey it in a way that I understand. Or maybe, you know, they're talking about icons, or they're talking about like nutrition things, like figuring out a balance between, you know, what do I really need to know? And I will not spend, what is it? Like, I think what it is, it was like a year out of your life reading these things. Like, nobody's going to do that.
Yeah, and of course that the collection of that information is really just the very beginning, because I can very legitimately collect information for all of the purposes that you listed out, right? I need this in order to make that decision, et cetera, et cetera. But then once that information is sitting there, and it now moves on to some other domain, there can be much more nefarious purposes for that information. And I wanted to also just agree with Jeff on his point about caveat emptor, though I see it from a different perspective. I think that the line that we crossed that has really invalidated caveat emptor is really our understanding of the production of dopamine. This is knowledge that we didn't have in the days when that law was passed. And, you know, to the extent that people can be viewed as a mechanism, we can therefore exploit those mechanisms for whatever purposes, right? And that's where the new thinking needs to be, right?
I want to try to pivot the conversation a little bit here. I think we've explored this a lot and got a lot of understanding here. But in our previous discussion to this, we talked about global opt-out, and I think we had some good conversation there. But the ADDP actually covers data brokers, even though a lot of people don't realize that, because they use a new term called third-party collecting entities. Whatever the hell that means.
Yeah, that one. See above, recovered entities. Can we like pivot the definition on that one too? That would be good.
Well, data brokers don't like to be called data brokers, I don't think. It's sort of a nasty term in the industry, apparently. But what really the ADDP calls for is regulation of data brokers, right? Registration, at least, of data brokers, and it pretty much creates a global opt-out. It almost really enacts most of what the Delete Act calls for, which is another piece of federal legislation that's sort of sitting on the bench back there, which would have the FTC create a registration for data brokers and allow consumers to sign up to opt out of tracking by data brokers, which is pretty darn cool. And nobody really even seems to be talking about this aspect of the ADDP. And I'm sure Christian's pretty happy about this if he didn't realize that was going on.
Yeah, when Tom mentioned it the other day, that was the first time I heard this come out of someone else's mouth than mine, the whole idea of being able to opt out of all of it, right? That's what I've been saying for a long time, right? Like, I want to do not call this on all my data. And he kind of said the same thing, right?
Yeah. So, so it's a pretty cool idea, though there does not seem to be a heck of a lot of enforcement, though I'm guessing that the FTC's ability to do rulemaking here would make it pretty strong, though I don't understand exactly how that might work. I don't know if Odie, if you have any thoughts or understanding of how that's going to work.
Yeah, so this is the part where I don't have a crystal ball, but every time in retrospect that it turns out that I had predicted it correctly, I'm proud of myself. So I remember having a conversation with somebody literally 7 years ago, I think. And we were having a conversation about this, about data brokers. And he was like, well, data brokers are not regulated in the US. I'm like, no, the FTC is really annoyed with data brokers. He's like, yeah, whatever. And it's true, the FTC was very annoyed with data brokers, and well, not data brokers as a concept, but with, I'm using this sort of colloquial shorthand, right, for, invisible processing for purposes which are not anticipated by people and with respect to which they have no control, right? And the FTC has this 2014 paper about data brokers, basically saying, hey, transparency and, choice and things. And basically that is what's happening both in CCPA and in the new law. So basically it tackles it, I think, from two separate ways. One is this concept, sort of US, I think it's a US based concept of like the do not call, right? Do not call, like with the phones, right? That you can add the phone numbers. So the piece on the third-party data collecting entities, where there will be a registry, and in the registry you will have your notices, and then you can do this global opt-out for the registry. That is one part of it. And then the other sort of, the corollary to that is, okay, so I can't have this place where, I opt out of things, but it's not all of the things. And I don't know how the other things are interconnected. And I still don't understand what is going on with my data. And that part is handled in other places where, and especially in the regs, you see it very clearly in the CCPA regs, and in the federal law, that doesn't go into the details, right? But the note, for example, if we look at the CCPA regs about this, they're saying, okay, well, you need a notice at collection. The notice at collection that you get, this is basically, right, like the European concept of joint controllership, and the disclosures regarding whatever Plan 49 and things like that. If you are a website publisher and stuff is happening on your website, and it is, some of it is for you and some of it is not for you, but like you benefit and they benefit and arguably the consumer benefits, fine, but these are independent entities, the collection of which is facilitated by the entering of your property, because they were talking about like Wi-Fi supplier in the regs. One of the examples is like your property or your website or whatever. Like you are the gateway to this, and you then need to at least give people a sense of what's going on, so they can then go and have some control. Because if you go to the data broker registry, like, okay, I'm going to opt out of everything that I can, maybe I want to, maybe I don't want to, but I have no idea what I'm actually opting out of unless I somehow found this out by accident, right? Whereas the flip side of it is when you get the transparency needs to be such that that gives you a better sense of what's going on behind the scenes and gives you control. Now, those are good in principle, and those cover some of the situations, but then, you know, obviously, if you have, obviously, you know, the EU experience, and if you're looking at like the ad tech market and real-time bidding and all that, and you're looking at like, you know, the Keneal decisions, the Towery and all that, okay, like, is it really possible for you to, you know, not possible, but like feasible, normal, and, you know, helpful to normal people to then have those lists of third parties that you scroll through and, you know, X out of all of them or X into some of them, and do you really know what you're Xing in and out of? So that is the same problem of, okay, we want how do we provide disclosure and control, assuming that, let's assume for the sake of argument that we have sifted out those types of sharings that we shouldn't have done. And as you guys know, there are lawsuits and things with respect to the concept of like RTB and whatever, TCF, and those that say that the design, I mean, there's litigation, right? So one side of the litigation is saying the design of them is such that is meant to interfere with the choice or whatever, right? So let's say we take that out. There's still going to be a lot of sharing and a lot of stuff. And then the question is, okay, well, what is the way for us to get this in front of people in a way that they understand and that gives them the most, you know, choice and control over what they want done?
Yeah, it becomes complicated. So if we actually implement this, how does the ad industry, for instance, you know, do ad tech? That's what you're asking, right?
Well, I mean, so in that, I don't know the answer. First of all, I don't know the answer to that, but the argument that I've seen and read in the litigation, right, the RTV litigation, the TCF litigation, the argument is that the industry is structured in a way that, you know, it's structured in a certain way that itself, like the structure itself, creates issues. So then the question is, right, and that is now being, you know, TCF is being, you know, there's a solution that is, I understand that IAB has filed a solution which is under review in Belgium and is still pending review, right? And RTB is pending review in the UK. But in parallel, right, because of maybe this, but also kind of deprecation of cookies and deprecation of tracking and stuff, there is a different maybe stream of data collection which is being carried, which is being developed, right? Like first party data and whatever. And in that situation, okay, if you are, you know, looking at collection and sharing in a way that is more limited, number one, like you're starting from, maybe you're not starting from scratch, but you're sort of starting from scratch. And then you're like, well, you know, a lot of people do like the convenience of, I don't know, you know, sharing certain information, being offered certain products, having an autofill of their little form with a number of partner organizations so they don't have to keep filling it in, right? So one, there is exploring this. And then the other, I think, stream is exploring achieving a similar purpose without the data and without sharing the data. With contextual, with, you know, building types of, you know, going off of preferences and attributes rather than specific tracking. There's different, like we went, like it's like the Robert Frost song, right? Like we went and diverged into one road, which is like RTB. And now we can't imagine, you know, the road less traveled by, which is not RTB. So we just can't think of like, what are the other options? But maybe there are options.
Yeah, I really see two things going on, assuming all of this happens, right? One is that there are a lot of people that are going to opt into behavioral tracking because either they like it or maybe because they make dumb choices, right? But I also think it's going to spur some incredible innovations that will allow us to do a lot more with a lot less personal information.
I was also wondering something. This whole problem space that we're just discussing has actually an antecedent, which is the medical industry. So I was wondering, how much of HIPAA law do you think could be repurposed for this sort of grander field that we're discussing?
Unpopular opinion is that I think, for example, I don't know that, the solutions that we're advancing in, CCPA or the ADDPA or GBR are arguably not more strict than what we have with HIPAA. HIPAA has a very, was legislated with a very specific purpose, which wasn't originally even protection of privacy. It was like insurance and stuff. And it is very, contrary to popular belief, it actually deals with a very limited set of circumstances for data. It is data that is supposed to be used for the purposes of treatment and payment and like operation of your, covered entity, not under the ADDPA, right? Like under HIPAA. It's for a very limited and very limited set of entities. And it's not, health apps. So I think, and I'm not a HIPAA expert, but my understanding is that this did not contemplate a world where there needed to be sharing or, or any collaboration would be like for a very specific purpose and for like research and stuff. And it wasn't, sort of widespread collaboration as we're sort of, thinking about in the internet or apps or whatever.
Sure,
So,
but there is a framework there already that could be perhaps extended because the participants, the character of the participants is changing, and maybe the ways in which the data is transmitted or used or whatever is different. But it seems to me like it could be a core for the bigger problem.
I don't think it's very good. I don't like the idea personally.
I mean, I think the federal bill, and CCPA does it, and now with CCPA did it with a sort of minimal touch on, okay, we're gonna treat sort of more, I'm not gonna say problematic, but let's say less expected sharing with a sale opt-out. And that was a start. And the concept of sale is really complicated, and it's not sale as everybody thinking, because you say this. I was talking to a friend of mine who's not a privacy person, and he's like, what do you mean they don't sell data? I'm like, they don't sell it because that's not what you think. It's like, so they started with this concept, and it did tackle some of the things, but now with the concept of the compatibility and the purpose limitation and the actual consent opt-in situation, I think they put more boundaries onto the sharing than arguably we have in like the pre-existing laws.
Yeah, and in fact, if we go back to the data broker stuff, the third-party collecting entities, one of the great things about that is the definition there is a broader definition than, like, for instance, CCPA has. At least in my understanding, it actually talks about, I forget now, monetary consideration or something like that in its definition. So it doesn't even talk about sale. So there's no question about, did you sell data versus, offer it to somebody for some other reason. So it's easier to classify these third-party collecting entities as data brokers. You can't wiggle out of that definition nearly as easily in the ADDPA. All right, guys. Well, we're 5 minutes after the hour, though we did start a little bit late. Maybe wrap this up a little bit. Odie, do you have any final comments? I think I've come to the conclusion that I think this is a pretty damn good bill for consumers. It does give us a lot more, I think, than we have now. We didn't really get into preemption or talking much about the private right of action, which frankly a lot of other people have been talking about. There are some considerable limitations to the private right of action, but the fact that it even has one is pretty amazing, given that this has some possibility of passing. I think the fact that there's a preemption here is good because we do have to have some level of consolidation of our privacy laws. But the fact that it has some limitations as well is great because some of the federal legislation that it's leaving in place is important. We need to have, COPA and a lot of our anti-discrimination laws that touch on privacy stay in place, and the ability for states to be able to have legislation like BIPA and to continue to pass new laws that impact privacy in new technologies like facial recognition, I think is important. So I'm pretty happy with this if they would pass it the way it's currently written. Anybody else want to comment on that before we wrap up?
Yeah, I mean, I think it's got a bunch of stuff, right? We didn't talk about all of it, but it's got, first of all, definition of personal information is broad. It specifically mentions biometrics, it specifically mentions sensitive data. It's got very strong data minimization. It's got a bunch of actual European style consent for specific, more sensitive uses, right? It's got an obligation for privacy by design with anticipated FTC guidance on it. It's got transparency with additional guidance. By the way, with the transparency, one thing that I haven't seen much talked about, I just want to mention it. So there isn't a cross-border transfer issue, but when they said transparency, they actually say you need to specifically note whether or not any data is transferred to, processed in, or other made available in the People's Republic of China, Russia, Iran, or North Korea, which I think is an interesting thing to note. You've got consumer rights, you've got access, correction, deletion, consent, objection. You've got specific issues with targeted advertising, discrimination, algorithmic transparency, and impact assessment. You've got age 17 as your cutoff, which is, high. You've got a bunch of things for large data holders with executive responsibility and oversight. You've got chief privacy officer, chief security officer, mandatory, governance type things. You've got service providers and third-party downstream, diligence and enforcement. And you've got technical compliance, which is basically like, GDPR style codes of conduct and certification, which is cool. And then you've got something that also lets some of the existing laws, survive. So they, so that's, I think it's it's much more than we have now. Yeah, considerably more.
And I agree with you too on the impact assessments. While it doesn't say that you have to do impact assessments in all situations, you pretty much have to do them, or else you can't really comply with the rest of the law.
That's why I think you hit the gist of the impact assessment while leaving the level of complexity of it to, well, maybe FTC regs and interpretation, but also kind of there is a situation where I've seen, I looked at this because I spoke at the CPPA stakeholders thing about DPAs, and I was looking at it, and there's a bunch of models in Europe. So there's the UK model, which is very kind of, easy to use, open-ended, but then maybe some companies are not going to do the deep dive. And then there's a bunch of things in the middle. And then there's the German model, which, like, if you're an SME, I don't know. I mean, good luck to you. I don't know what you're doing, because the level of, the level of specificity and complexity that needs to go into a DPA for it to be compliant is really difficult. So I think this kind of, takes that into consideration and maybe strikes a balance of, okay, like, we're going to leave this up to you to how to do it. And it depends. If you're a 5-person company, if you sit there and think about it and like implement whatever, okay, well, you don't need 500 pages. But if you are a 5,000-person company, arguably, if you're a large data holder, hey, you've got to do all of this stuff. Otherwise, you're going to be in trouble.
Yeah.
Yeah. I mean, I can't speak to Germany. Obviously, I taught privacy law 20 years ago. Well, 25 years ago now in Germany, specifically to call center agents at the time. So the discussion over there is way more evolved because they've been having it for 2 decades at this point in time. So the discussions that we're having here are somewhat lagging in that regards. A lot of more people are way more sensitized. I mean, when I first moved here. A lot of people that I've talked to have already heard that, but I was shocked. I was just shocked that there was companies that were just in the business of collecting my private financial information and selling them. I first honestly thought that was a joke. I thought that wouldn't be possible, because that would literally be a criminal organization under German law. That it would not be possible to do that, which seems still very normal to me. That should be the response. Put people of the executive level at TransUnion, Equifax, and the other shysters into prison right now, right? I don't see a problem with that.
Well, this has been a really interesting episode. I'm really thankful for your insight, Odia and Chris, and who we also had
Eric.
Heidi and Eric, right?
Yeah.
And Tom for showing up and at least showing his face. He didn't get to talk, but Tom Besor. So thank you everyone for all this wonderful insight. This has been episode 16 of Your Bites, Your Rights, and we hope you'll join us again next week. Have a great weekend, everyone.
Thank you.
Again, sorry for the delays.
Yeah, well, we got through
Thank
it. Take care, everyone.
Thanks, guys.
Bye.
Talk to you soon.
Bye.